of 9. You're still live here on 3FM Sunrise on 3FM 92.7. Do keep your thoughts coming on our socials. And you can find us on X, we're on Facebook, also on Instagram. The hashtag we're using this morning, it is hashtag 3FM Sunrise. And very shortly we'll be zooming into matters concerning the petition for the removal of the Chief Justice. Now, we know that there have been some suits against the CJ petition, and D-Day is today, April 9th. The Supreme Court is set to hear the Injunction case. But if you're wondering exactly what these cases entail, do take a listen to my colleague, Lord Iduasare. And he's also going to be stationed at the Supreme Court, and he'll be giving us a play-by-play on what exactly is going on.
The two suits by MP for Otafo, Vincent Asifwa, and citizen Emmanuel Seusu are seeking similar release from the Supreme Court. Represented by former Attorney General Godfrey Boadame, the Otafo legislator wants the Supreme Court to declare as unconstitutional the precedent forwarding of 3 petitions against Chief Justice Gertrude Torkornoo to the Council of State for consideration of her removal when she had not been notified of the petitions. He is also seeking the Apex Court to declare the actions of the President as an unjustified interference of the independence of the judiciary. For Emmanuel Seusu, a citizen, he is requesting for a restraining order against the President from proceeding to consult with the Council of State regarding the removal of the Chief Justice. Again, he's seeking an order preventing a committee from being constituted to inquire into or make a recommendation on the petitions to remove the Chief Justice. The injunction application, which was scheduled to be moved at the Supreme Court on Wednesday, April 2, pending the determination of the substantive suit, has been scheduled to April 9, as seen on the course list of the Supreme Court. It's been 7 days since President Mahama finished the 3 petitions to the Chief Justice and ordered her to respond within 10 days. It remains to be seen if the applicants in the suit will withdraw their case at the Apex Court following the recourse action taken by President Mahama to grant the Chief Justice to provide her response to the petition. Lord Iduasare, TVC News.
All right, again, that was my colleague, Lord Iduasare, giving some context there for those of you who are uninitiated. Well, subsequent to that, Chief Justice Gertrude Torkornoo has submitted her response to 3 petitions calling for her removal from office. The responses, which were submitted to the President and the Council of State last Friday, paves the way for the continuation of the consultation process with the Council of State in accordance with Article 1466 of the 1992 Constitution. You'll recall that the CJ asked for some 7 days to make her response known. President John Dramani Mahama actually gave some 10 days within which she was to respond to the 3 separate petitions calling for her removal, although it is unclear what allegations have been leveled against her due to the confidentiality demanded by the process. Now, if the Council of State finds merit in the allegations against the Chief Justice vis-a-vis her responses, a committee will be set up by the President to inquire into the petitions and recommend to him whether the Chief Justice ought to be removed from office. Now, the committee, according to Article 1466, must consist of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. And so today we'll be taking you directly to the Supreme Court and also gauging the mood ahead of the hearing of these 2 petitions that have been brought forth to the Supreme Court. And Crosby is still in the studios. And also, if you're following us on Facebook, we have that up on the screen. And this one was filed by Vincent Asifwa. He is the MP. Crosby, remind me. Otafo. Yes, that's right. Otafo. That's his constituency, and he's seeking a number of reliefs. If we can scroll down all the way to summarize exactly what it is that he is actually looking for. Let's move on. Yes. Let's move on. We want to get to let's go for the jugular. What exactly is he seeking for the courts to do today?
So
No, let's go all the way down. I believe that should be towards the end. Relief sought. Let's go all the way down. We'll scroll down if you're following us. Okay. All right, I'll pull that up. I'll pull that up on the phone and we can speak to the specific release. But Crosby, today we are going to the Supreme Court.
Exactly.
Although it's a very thunderous, morning. The heavens have opened. Is that a sign of things to come? Is it a sign of things to come? Typically when the heavens open, you're expecting something great to happen today.
Although this is something we know, but anytime it happens, it looks as though it is very new. I mean, with how this case has traveled so far, from when the president received the petition to the suits wanting the CJ to get copies of the petition, to the CJ writing to the president that I want to see the petition, to the CJ again now responding to the petition, the committee being set up and all of it. Now today we're hearing the injunction application that has been filed. It's a big day. Nobody really knows what to expect.
That's right.
Mind you, the empaneling, we understand, will be done by the Chief Justice herself, who is
That's
in the
for
middle.
Today, you mean?
Yes, for today. Who is in the middle of all of this? There's a conversation about the possibility of suspending her even before the case fully travels. That's also something that we don't know whether or not it will happen. So it's just interesting. However this goes, everybody will be interested. Everybody will want to know how it travels, where it travels to, the people who will be affected, and how, the entire country will react to it, because it will shake up the judiciary, if you like, whichever decision that comes out of it.
We're going to see some precedents being set. So Honorable Assefoa is seeking several declarations from the Supreme Court, whose original jurisdiction he's invoking. Now, regarding the interpretation of constitutional provisions governing the removal of a Chief Justice. Now, his suit argues that the president must notify the CJ and obtain the comments of the CJ before initiating consultation with the Council of State on the matter. Now, the reliefs sought. The plaintiff requests that the court declare the president must notify the Chief Justice and obtain her comments as per Articles 1461, 246, and 7, Articles 23, 57, 3, and 296 of the Constitution. Now, he's saying failure to notify the CJ before initiating the consultation process with the Council of State is a violation of Article 1466 and undermines the constitutional protection of the Chief Justice's security of tenure, and of course any other reliefs, he says, that the court might deem fit. Very shortly we'll connect with a private legal practitioner to put some more flesh on the bones on what the implications could be this morning, depending on which way the pendulum swings. But of course, this is still 3FM Sunrise on 3FM 92.7.
The best in the morning is on 92.
The time reads in the studios. Let's get onto our phone lines and speak with Osman Al-Hassan. He's a private legal practitioner. And we're talking about the CJ Removal Petitions. You know the Supreme Court will be hearing the injunction applications today. Osman, hello, good morning to you. Hope you're doing well.
Great. I hope you do too.
I'm doing all right. Thank you so much for joining us on the show this morning. Let's get straight into it. What is your legal take on the claim that failing to notify the Chief Justice before initiating consultation is a violation of her right to a fair hearing under Articles 23 and 296? That's how the conversation actually started before we saw that opportunity given to her to respond to these petitions.
Well, in these circumstances, let me caution that we need to be cautious because the matter is still pending before the Supreme Court for the determination of sin, isn't it?
That's right.
We need to, but if you ask my opinion about the right of any Chief Justice, and let's not particularize it and personalize it. It's about the office. Any Chief Justice has a right to be heard before her removal, but at a particular stage. My opinion has always been that if the petition is, and it's not my opinion, it's actually an express or a constitutional provision and an express interpretation by the Supreme Court. You see, yes, when a petition is made or is submitted for the removal of a Chief Justice, what is the first thing to do? That's what we should be asking ourselves. The first thing to do is for the President to whom it is submitted to look at it and establish a prima facie case in consultation with the Council of State. All right. Now, what I keep explaining what this prima facie case is over and over again. I don't think I should belabor it here. But the first step actually is for the President to establish a prima facie case, which means that it's going to determine in consultation with the Council of State whether a case is sufficiently made for the person against whom it is made to bring a defense or to answer. Because if a case is not sufficiently made for you to answer, it means even without your answer, the claim is not founded. So it ends there.
Right.
Yes. So at that point, the Chief Justice will not be heard, or there's no need for the Chief Justice to be heard. And secondly, the process remains confidential. And confidential here means it is limited only to the people involved in the process. And you can see, constitutionally, the Chief Justice is not involved at this stage of determining prima facie case. It is just between the President and the Council of State. And if at that stage the petition is released to any other person, even including the Chief Justice, in my opinion, it will constitute a compromise of that confidentiality.
Right.
Because that can also be a conduit for a further publication and all. Okay? And so for me, the Chief Justice, any Chief Justice at all, or any person at all, is entitled to be heard before you are condemned or before you suffer a loss of a right. But in this particular case, the stage at which the Chief Justice is entitled to be heard is actually the committee stage. You know, the next thing after establishing prima facie case by the President in consultation with the Council of State is for the President to now constitute a committee to investigate the allegations further. Now, it is this committee in its investigation that will now summon the petitioner and the person against whom, or the Chief Justice, to be heard. Because the petitioner perhaps will have to be cross-examined by the lawyer of the Chief Justice or by the Chief Justice herself or himself, as they may choose. Okay? And they will also now bring their defense. So in bringing your defense, you are entitled to be heard. You will be heard at that stage.
Right.
And now, after the hearing, the committee will now finalize its investigation and make a report, compile a report, and submit the report to the president for the president to now take an action. So for me, of course, the right to be heard is sacrosanct. We call them rules of natural justice. You cannot condemn any person without giving the person a hearing, though that is what is rife these days, even among the people who have knowledge of judicial processes.
Right.
Yes. So for me, my opinion is that she is entitled to be heard. Any person is entitled to be heard before, but we need to also look at the requirements of the Constitution, because that is the highest law of the land.
Certainly. Now, with the Supreme Court hearing injunctions today seeking to halt the process, do you agree with critics who say that this is an interference of the executive's duties? Or do you believe the judiciary has the right to protect its own from what could be perceived as attacks on their administrative head?
Well, I don't know what, to be honest, I keep saying I haven't read the application for the injunction, and I don't know what they are seeking to injunct, to stop from proceeding. Are they seeking to prevent the procedure for the removal of the Chief Justice? Now, if they are seeking to stop that procedure, the question is on what grounds? Now, if the ground is the right to be heard, two things have happened right now. One is my explanation that it hasn't gotten to the stage where the hearing has to be conducted.
Right.
Two, there is something that has happened that would seem to even preempt or render that application moot, if that is what it's asking for. Because what I see in social media that, and I hope that's correct, that the president has forwarded the petitions to the Chief Justice and has given her some number of the 10 days to respond.
In fact, those days have expired, and we know that Chief Justice Tokonu has submitted her response to the three petitions calling for her removal.
So in that case, if the grounds for now stopping the process is that she was not giving a right to be heard before anything had happened, or before the forwarding of the petitions to the Council of State, wouldn't that be moot? Though some people will say that, okay, the request is that it has to be given to her before it would be forwarded to the Council of State. There is no constitutional provision that is mandating that. There is no law that is making that requirement of the President and the Council of State. So at least, it is for the Supreme Court and the parties to tell us what requires this demand. But if the President has already done so, wouldn't it be that, okay, what the grounds for which you are seeking to stop the process is already fulfilled? Yes, she's been given she made a request, and the request was complied with. Give me the petition, and the petition was given to her. And so she has submitted a response according to you. So now what will be the grounds for injuncting the process? There's no grounds, in my opinion, at the moment, for injuncting the process if the only grounds that started the application was that the Chief Justice was not giving a hearing. Because for me, now, the hearing is given. So the application might be rendered moot. And if it is not moot because it was not given before the forwarding. In fact, it should be a matter of fact to be established whether the petitions were given to her after the forwarding to the Council of State or before.
Right.
And even if that is established, then we now ask ourselves, yes, so which law, which provision of the Constitution is violated in that regard?
That's right.
Because Article 146 is clear, it's very clear about the process. And we all know that in express provisions of the Constitution, there's even no need for a prima facie determination to be made in respect of removing a Chief Justice. It is the Supreme Court that has added that for various reasons, which I can't cite here for time.
Right.
And yes, and so if they have added it and we are following it, I have my problem actually with that addition, because I think it is something that must be done by constitutional amendment, not by judicial interpretation. Yes, but it's there. So 146 is clear, and if any provision of 146 is violated by the forwarding or by the consultation of the President with the Council of State, I think they have to isolate that and identify it and show it to us.
So, Mr. Al-Hassan, what I hear you say is that if the reliefs that are being sought today have already been enacted, then really the whole exercise is null and void, because whatever reliefs were asked for, we've seen in motion. Now, should the Supreme Court grant an injunction today, and this is just an if, we're speculating on the number of outcomes that we could see today, and it could go either way. What implications does that have on the consultation process and the rule of law in this matter?
Well, I don't think, my opinion, and I'm speaking prophetically, so to speak.
Certainly.
As we always say, I can't tell what the Supreme Court will do, but of course, what they say will be the final word after review. But I don't think that the Supreme Court will be granting an injunction to stop the procedure at this stage. But if it happens that they have granted such an application, then of course we will be looking to see the grounds from which that injunction will be granted. Because let's not forget that, as I said, the Constitution is always the highest law of the land. And any other law that is not consistent with the Constitution must give way to the Constitution. And so if the order is not consistent or is in contravention with an express and clear provision of a Constitution, then of course we will have a serious conundrum, because the President and the Council of State will be put in a fix whether to obey an express and clear provision of the Constitution or to obey a remote and far-wide interpretation of that same Constitution.
So that could certainly open a can of worms.
Yes, of course. That will be actually a novelty, but I believe we will handle it. And this is what I think the Supreme Court should be avoiding decisions or interpretations of the meaning of the Constitution that fall out of the semantic possibilities of the words used. There's something we call semantic possibilities in interpretation. When you mention a word, there are a number of meanings that can be assigned to that word linguistically. And if that meaning is foreign to that expression in the Constitution, it means it is an addition of an idea to the Constitution and not an interpretation of the meaning of the Constitution. No matter how you look at it, you may defend it that it is purposive interpretation, objective purposive interpretation, and all that, but it will not sit well with the Constitution. I have my own issues with the application of modern purposive interpretation, because I think much understanding is not had of it by those who are applying it. And so we are getting into several conflicts. The interpretations are getting into conflict with express and clear words of the Constitution, which is not good enough. I think this is what the Supreme Court should be avoiding.
Certainly.
And so I believe that the Supreme Court in this will try to avoid that. But if it happens, it becomes a conundrum that we have to navigate.
What are your thoughts on the optics of Supreme Court judges potentially sitting on a case that involves their administrative head? Does this raise issues of conflict of interest? It's come up a number of times in this conversation, or is there an issue there with judicial ethics? What are your thoughts?
Well, there's who, in fact, who else you sit on it? There's something in law we call a principle of necessity, okay, which was applied in the Judicial case. It was applied in the Kosi case. We have a history, you know. Yes, there is also a principle of rules of natural justice we call what's it? That you cannot be a judge in your own cause. Is that not it?
That's
I
right.
believe that's what you are. That's what your question is referring to.
Indeed.
You know, yes, you can't be a judge in your own cause, but this is administrative. What the Chief Justice, what people will think about the process as or any semblance of rules of natural justice attributed to this situation will be that, okay, the Chief Justice is the one impaneling the judges to hear the matter, and she is the one who is a party to the suit. Okay? But the question is, the Chief Justice has a constitutional duty to impanel.
That's right.
She has a constitutional duty to impanel. And so the constitutional duty becomes a necessity, and necessity breaks all those rules. Because if she doesn't impanel, who will impanel? According to the Constitution, who will? You see, and we are supposed to assume that the Supreme Court judges are not the poodles of the Chief Justice. They are independent thinkers and judges. They are supposed to be, in a way. So they cannot be influenced by. But of course, people will think that, okay, they are colleagues. Some will be more sympathetic to the Supreme Court, to the Chief Justice, and perhaps the Chief Justice will impanel those people to look at it, and that will influence the final outcome. I don't think it is a possibility, but I don't think it is plausible. And even if it is, it remains it remains a necessary evil, because there's unless we all come to the conclusion that, okay, let's amend the Constitution and also say that, okay, in circumstances where the Chief Justice is involved in a suit before the Supreme Court, then it becomes one of the grounds where the most senior Supreme Court should be acting as the Chief Justice and impaneling members. It also is fine. It's also fine. But
I mean, that could maybe improve the optics for the everyday Ghanaian, don't you think?
Yeah, the optics, of course, the optics for the everyday Ghanaian and people who are not lawyers will not be good. They will think that, okay, the Chief Justice is being a judge in her own cause, but she has had to impanel members of the Supreme Court to hear her own matter. This is not the first time it came up. It came, as I said, it came up in Judicial, where Justice Appiah was being removed. You know, when the Supreme Court had to determine an issue around a petition submitted by Brighter Question. Okay, it came up, and the Supreme Court, in reference to an earlier case by in Kosi, said, well, it's necessary. There's nothing they can do about it. It is the Chief Justice who must impanel. But I think we can navigate our way by amending the Constitution to say that in such cases, because you know that any time the Chief Justice is absent, then the most senior of the Supreme Court bench will act as the Chief Justice. And you also know that in this process, Article 146, as soon as the process is started, or the the president is in consultation or forwards this to the Council of State, the petition to the Council of State, and establish a prima facie case or otherwise, there's a stage at which the president can actually suspend the Chief Justice from acting as a Chief Justice. So that is a cure to that situation. But if it hasn't happened, if the president hasn't used that, then the Chief Justice remains the Chief Justice and must act according to her constitutional dictate or duty to impanel the judges. Because there is no any other way in the Constitution to deal with it until we make an amendment to the Constitution to add to the current remedy that, okay, when the Chief Justice is also in such a circumstance, even if he or she is not suspended by the president, it becomes necessary or it becomes one of the grounds that necessitates the acting Supreme Court judge to take over.
Certainly.
The most senior of the Supreme Court judges to take over the administrative work of the Chief Justice until the process is over. That could be another remedy. But till then, we will have to do with what the Supreme Court said about the situation, and it is simply that it is a necessity and must be done by the Chief Justice.
Now, speaking of amendments to the Constitution and also the everyday Ghanaian, do you think that a move should be made to amend the confidentiality clauses of Article 146 to make such proceedings more transparent in the public interest, or do you believe that confidentiality should be or should remain sacrosanct?
I think there's good reason for the confidentiality because the allegations made against the Chief Justice stand the possibility of affecting public perception and public respect for the judiciary.
That's right.
Because that's the head of the judiciary. And imagine that such allegations were out. And you see, public perception, I always say, public perception about anything is as dangerous as reality. So that if the public perceives that the Chief Justice is this way, it is as dangerous as the Chief Justice being that way, in fact. So, and perceptions are not formulated around truth only. As soon as the petition is out, the public might have already formed their opinions by reading, because they are not lawyers, they don't know the due process. They will come to conclusions, and no subsequent outcome of the process would be able to outdo that. And so for me, I think it is a good thing to protect the reputation of the judiciary and the Chief Justice as a person. But, of course, so in my opinion, I think it should remain sacrosanct.
Right.
There's no need for amendment to change anything about it. And it doesn't cause anything. For me, the confidentiality doesn't cause any harm.
Right.
It rather prevents a possible harm. And so if it happens that the Chief Justice is removed, of course, it will be public as to the grounds based on which she is removed. But if it's not, then it remains confidential. Nobody knows what happened or what she had done.
I mean,
and it is conducive to judicial to public confidence in the judiciary.
Because you talk about public perception, and this is going to be my final question to you on this matter. If the Chief Justice is eventually exonerated, how do you believe this saga will impact public trust in both the executive and the judiciary moving forward?
Well, this question can be answered in this. Well, it can have an impact or otherwise. It can have an impact first because of how the public perceives the work of the Chief Justice herself as a member of the bench, the highest bench. Okay? Because now judicial proceedings, especially involving public or in public interest matters, most of the time are telecast. People watch it and form their opinion about what should have happened or how it ought to have been. And you would see that already, even before the petition, people of the public would have formed some opinion about the Chief Justice. And even the Supreme Court. You know, we hear at some point people making reference to unanimous SC.
That's right.
You know, yes, trying to ridicule the Supreme Court. I don't subscribe to that, but that's what is. It is because of their concept of justice and what they see the judiciary administering. And that's why most of the time in some other platforms I have made reference to Article 125 and the fact that justice emanates from the people and is only administered by the judiciary on behalf of the people. And so at all times, I think the judiciary should administer justice that is not foreign to the public concept of justice. And our rules must be made. The judicial process, the rules governing the judicial process must be made to fit with the public concept of justice. So if they see something as injustice and it goes to court and come out as the justice, it becomes an issue. And for me, that is why we find people making those derogatory remarks about the judiciary. And so already, for me, I think there is some public perception about the Chief Justice already. Okay? And because of that, if the petition, the outcome of the petition, or if the Chief Justice is finally absolved, it will not change that petition that has already existed even before the petition.
Right.
But of course, the confidentiality of the contents of the petitions will now prevent a further aggravation, because if it were to be out for the public to see, it probably might aggravate the already existing public perception about her. You know? And so for me, the outcome, a positive outcome or an outcome in favor of the Chief Justice, may not change much about the perception already formed about her. But of course, some people might also change their perception because a due process has been followed and she has been absolved.
Interesting perspectives there. Thank you so much, Osman Al-Hassan, private legal practitioner, for engaging with us this morning and for giving us some much needed nuggets to expand on this conversation. All right, again, Osman Al-Hassan, private legal practitioner, weighing in on the CJ removal petitions. As I mentioned, we have our eyes and ears on the ground. No action, I'm told, has started just as yet, but all throughout the day, do stick with us right here on 3FM 92.7 so that we can bring you up to speed on exactly what is going on. Let's listen to an explainer, though, on exactly what it is that is going on for, again, those of you who are uninitiated.
Provides that a justice of a superior court shall only be removed from office for stated misbehavior, incompetence, or on ground of inability to perform the functions of his office arising from infirmity of body or mind. If a person seeks the removal of the Chief Justice, he must send the petition to the President. The constitutional provision originally only required the President to, in consultation with the Council of State, appoint a committee consisting of 2 justices of Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, to inquire into the petition. The Supreme Court, in the case of Frank J. Chum versus Attorney General, explained that it was necessary for the President, in consultation with the Council of State, to first determine whether the prima facie case is disclosed in the petition. This is a process to decide whether, at first impression, a person will conclude that the petition raises issues worth inquiring into. Minister of State in charge of Government Communications, Felix Kwakye-Ofosu, in a March 25 statement indicated that the president had forwarded 3 petitions to the Council of State for consultation processes to begin. Member of Parliament for Old Tafo, Vincent Assefuah, has initiated a legal action challenging this referral. He holds the view that the president must make the petition available to the Chief Justice to receive her comments before this consultation. The Chief Justice has also written to the president asking to be allowed to respond to the petitions. The MP.
Yes, that's absolutely correct. The doctrine of necessity. There is no other person appointed and mandated to empanel the Supreme Court
this issue
the Chief Justice. For as long as the Chief Justice is there, it is the duty of the Chief Justice to do. I don't know if a Chief Justice will say, well, I want to allow the next person, the next senior person to me to do this. I don't know, but that's the duty of the Chief Justice, and you can't change the law.
Complicated, but history keeps repeating itself. You know that when Charlotte Osei was being removed, she also asked for a petition to study so that she can also respond to it. For me, on a layman's view, I'm not a lawyer. This issue is very clear. If you go to Article 146, 6 to 10, now I want to read it because law is an authoritative, course. What it means is that you have to quote it verbatim. Now I'm going to quote it. It says that where the petition is for the removal of the Chief Justice, that is 146.6, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. That is AS6. And then 7 says that the committee appointed under clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. Excuse me, that is...
So some extra perspectives there on this particular issue. But time check, it is some 5 minutes to the top of the hour, and then we're bidding you farewell. But of course, if it is your birthday today, happy birthday going out to you.